Morning. Let me find out a little bit about you, if I may. I'm not going to ask you to talk or try a case, just all I need is a show of hands for now. How many of you represent plaintiffs? How many defendants? Okay, what's it, about 2/3 plaintiffs? How many of you would say that you spend the majority of your time handling medical malpractice cases? Virtually everybody, okay. How many of you have already tried to verdict one or more medical malpractice cases? Almost everybody. 5 or more? About half the group. Okay. 10 or more? Okay, a lot. 1/3 of the group. Super. You hardly need us to tell you that for the next 2 days, although you're going to be hearing from a panel of the best trial lawyers in malpractice cases that I could assemble, there's no proof that any of the advice you're going to be getting from any of us works. There's never been, to my knowledge, any kind of controlled study or trial about whether our suggestion is the right way or the wrong way. It's hard to give a talk without giving our suggestions and suggesting that what we think may be the right way may indeed be the right way. Some of us on this panel will remember a few years ago when we were giving a talk in New Orleans, and the local lawyer there, deadpan serious, told the audience that the secret of his largest verdicts, right, was using pink chalk on the blackboard during summation. Those of us sophisticates from New York giggled at the suggestion that pink chalk could possibly be the secret to large verdicts, because we know that it's white chalk that is what makes things successful. So when you hear from any of us these notions that you're about to hear from the next 2 days, I know that you will all filter it through your own opinions. Issue selection is the first subject that we wanted to talk about here. It's a difficult subject to address because, except for generalities, everything else really requires some specific examples for me to make my point. Let me start with this generalization, if I may. The side that convinces the jury that their issues are the issues is the side more likely to win the case. What do I mean by that, and especially by this phrase, their issues? Aren't there, after all, only one set of issues in a case? Emphatically, he said, no, there's not only one set of issues. The plaintiff is going to be trying to convince the jury throughout that the issues in this case, and the only issues in this case, are, and I'm not going to give examples yet, so I'll just give them numbers, are 1, 2, and 3. And the defendant, in essence, will be telling this jury throughout the trial, absolutely not. Nothing could be less relevant or important than you're wasting any time thinking about 1 or 2 or 3. The only things relevant to this case that will govern your decision are issues A and B and C, says the defendant's attorney, with every question of every witness and every time he or she has a chance to address the jury. The issues that each side claims are the issues are, of course, carefully chosen by that side. How? Each side has decided that there are certain issues that in this particular case they can win, that they have by far the better of, the superior evidence, if you will. In other words, the plaintiff's attorney has chosen to say that, still avoiding examples for a moment, 1, 2, and 3 are the issues in this case precisely because the plaintiff's attorney knows that if anyone for a moment believes that those are the issues in the case, he'll win the case because he's got to win on those hand-picked issues. And it is precisely for that reason that the defendant must do everything throughout the trial to suggest that 1, 2, and 3 are not the real issues in the case, that the real issues in the case are the ones that the defendant has chosen. Again, why? Because on those issues, the defendant would prevail. If the plaintiff's attorney can get the defendant's attorney to start spending time, and the more time the merrier, especially, for example, questioning witnesses about the plaintiff's issues, 1, 2, and 3, or even better yet, to have the defendant call their own witnesses to specifically address what the plaintiff says are the issues in the case, then the plaintiff has succeeded in what? In having the fight be on his own grounds, on his turf, on his battlefield, if you will. Rather, the defendant's attorney should be doing what? Encouraging exactly the opposite, trying to get the plaintiff's attorney to engage in a fight on the defendant's issues, A, B, and C. To watch two masters of issue selection try a case is an enlightening experience. The only analogy that comes to mind as I thought about a couple of such trials is railroad tracks. They begin at the same place, they know they're going to end at the same place, and yet they never cross over onto each other's side. Let's take an extraordinarily simple one-issue example just to make certain that the principles I'm talking about are clear. Imagine, if you will, a brain-damaged baby case in which the care during labor really was poor. But in that same case, if you will, please imagine that it really does seem that the brain damage may not have been caused by that malpractice, but was rather probably due to some pre-existing congenital cause. I can imagine a couple of members of this panel smiling because they've just recently tried such cases. The plaintiff's attorney will be doing everything possible to convince the jury that there's really only one relevant question in this case, that their focus and time and energy and effort should be spent on was the care during labor here in accordance with good and accepted practice. And the defendant will be attempting to convince the jury that it would be a complete and utter waste of their time for them even to try and think about the issue of whether care during labor was good or bad. Why even waste your time on that issue at all when this baby's brain damage didn't come about during labor and delivery? Why analyze the quality of care during labor and delivery, since in this case it obviously had nothing whatsoever to do with the child's care, the child's brain damage? True. You know and I know what the judge will tell the jury, that the plaintiff has to prove both liability and causation. But it seems to me that there are cases in which the liability is strong enough, outrageous enough, if you will, that a jury may be lenient on the other issues that the judge charges them about, such as causation. In short, the stronger the liability is for the plaintiff, the more the plaintiff should be emphasizing that strong point. Liability, for example, in that case. There are many malpractice cases, not just the one simple example I've given, in which the plaintiff's case is stronger on liability and the defendant's case is stronger on causation. So let me give one other example that fits into that common theme. A failure to diagnose cancer case. The plaintiff may choose as its issue, wasn't it negligent for this gynecologist to feel this woman's breast lump, and to ignore it and merely tell her to come back in 6 months. The defendant may choose as its issue in that same case, and again, I've oversimplified to a single issue here for the sake of example. Given that this patient's cancer, when diagnosed 6 months later, was at stage 4, and as a matter of fact, she died only 5 or 6 months after that, can this plaintiff fulfill its burden of proof that the 6-month delay really was the proximate cause of death here? Now, of course, even in such cases, it may be that the plaintiff's best argument, best issue, is on proximate cause, so long as the battle can be translated into an issue on that subject the way that the plaintiff would have the issue. For example, the plaintiff may argue, is a delay in the diagnosis of cancer important or unimportant? That's the issue in causation in this case. If the issue is framed that way, what American hasn't been brought up with the notion that time is important in diagnosing cancer? Issue selection is something that consciously or unconsciously we all think about as we prepare not only for the trial, but throughout the discovery, and indeed long before that, in deciding whether to accept a given case. In a case involving failure to diagnose appendicitis, consider the choices that the plaintiff's attorney has in preparing for trial. Will I try and prove that it was malpractice on the part of the emergency room doctor not to know that this was appendicitis? I mean, after all, there was pain in the right lower quadrant, there was nausea, vomiting, fever, and child, and so on. Should have known this was appendicitis. Is that going to be the issue in this case? Or rather, would it be easier and therefore smarter simply to claim what the emergency room doctor should have known in this case was that what this child had is what's called a surgical abdomen, also known as an acute abdomen in plain English, one that required opening to find out what was going on inside. The doctors call that an exploratory laparotomy, and that was the malpractice. Failing to open the patient and look and see what was going on, because if they had, they would have found out that what was going on inside was appendicitis. Isn't that an easier burden for the plaintiff to take on? I've said that each side should be constantly telling the jury what the issues in the case are. So let me ask rhetorically, how do you do that? How do you tell the jury what the issues in the case are? And I think there are two ways. First of all, you just tell them straight out from the opening statement on. Ladies and gentlemen of the jury, the evidence in this case is going to present to you 3 issues for you to consider. First, second, and third. That's one way. And second, you will prove or demonstrate to the jury that those are the issues in the case with everything you do, with every witness you ask questions of, whether on direct or on cross. The jury will be able to see your focus and organization directed into those 3 subject areas. Now, the plaintiff, as you can imagine, has more influence on what are the issues in a given case. First of all, in almost every jurisdiction now, the plaintiff makes the first opening statement. Second, and we'll talk about this later today, it's become more and more common for the plaintiff to call as their first witness in a medical malpractice case, who? The defendant, or as we plaintiffs' lawyers like to call him or her, the culprit. And the issues to be covered will be what? They'll be governed by what the examining attorney chooses to ask about. in a case involving postoperative infections, should the plaintiff take on the burden of claiming that postoperative infections simply shouldn't happen, that it was malpractice that this patient got a postoperative infection? Perhaps the hand-washing practices were bad in the hospital or so on. Is that a smart issue to argue about? Or will it be easier in this particular case to prove that this postoperative infection should have been diagnosed sooner? That was the malpractice. Or in this particular case, would it be wiser to choose as the issue, when this postoperative infection occurred, it was treated improperly. The wrong antibiotics were given, and or in the wrong dose, and or via the wrong route, and or for the wrong length of time. An important decision, of course, especially for the plaintiff's attorney, is how many issues to have. You know, as attorneys, we are all taught from law school onward that, especially as to liability, the more theories, the merrier. We even have a name for it. We call it pleading in the alternative. And we believe at some instinctive level that if we throw enough things out into the wall, some of them will stick, because we know the law is that if the jury finds any departure and causation related to that departure, the plaintiff will win the case. Therefore, why not make as many criticisms as possible? It's odd the way we lawyers think of pleading in the alternative, because what makes sense to us is sometimes a joke to jurors. We attorneys might argue in a given lawsuit, what was the old example? I didn't take his lawnmower, and besides which I returned it yesterday, and in any event it didn't even work properly. Jurors may find this notion of alternative arguments, especially when they sometimes, as they often are, start contradicting each other, as an attorney talking out of both sides of their mouth. And worse yet, no matter what the judge charges the jury, and no matter what we've been told that the law is, there are jurors out there who will believe that if you lose on any one point, you should lose the case, especially if you're the one who's told them this is an issue in this case for you to decide, and you're wrong about it. And so I suggest to you that if you're not going to win the case on your strong points, you're not going to win them on your weak points. And it's important in trial law, as in all sorts of battles, to concentrate your strength where your strength really lies. It's commonly said, and I think it's true, that at least for the plaintiff, the thrust of any case, especially a medical malpractice case, should be simple and straightforward. But it may be better for the defendant not to be choosing, as the plaintiff will, the more understandable issues, but rather perhaps more esoteric ones. Am I clear about this? The plaintiff, when selecting issues, will, all other things being equal, want to select issues that, since they're right about these issues, the jury will understand. Okay? Defendants are often the ones pointing out what? How complicated medical decision-making is, how difficult judgments are, how extremely controversial this field of medicine is. And indeed, I think it's true. The defendants are more likely to win the case if the jury is confused about the facts or the law or the underlying medicine or even what the issues are in the case. Certainly one perfectly appropriate consideration for the plaintiff in choosing the issues in a case is whether there are issues that may encourage the defendants to argue and fight amongst themselves. For example, in a case that involved the infiltration of an intravenous line in a scalp vein in a newborn baby, the issue might have been whether such an infiltration represents carelessness on the part of a caregiver. Instead, at the depositions in this case, an interesting thing happened. Each of the caregivers happened to deny that they were the particular one who started that particular IV. Issue selection. What was the issue at the trial? Not whether or not the infiltration was due to carelessness, but rather which one of these defendants is the culpable one. That'll be the only question for you to have to figure out in this case. They've all denied being the one responsible. There must be a reason why they're all running from it. Your task will be to figure out which one of these defendants is the culprit. Needless to say, and we'll spend a lot of time talking about this over the next 2 days, credibility can be not only an issue in the case, it can be the issue. But I've taken such simple examples. Let me give you a more common number before I finish. We started off talking about an obstetrical malpractice case. Let me do that as one final example. And what I hope to illustrate by this example is that the defendant's choice of issue selection is not no, not one, no, not two, no, not three. That's exactly the opposite of what should be done. So, for example, in a case where the plaintiff is arguing the first issue in this case is whether during labor this fetus was in distress from a lack of oxygen. In a case where the plaintiff says, I'm definitely going to prove that. And the second issue in this case is whether or not this baby therefore needed to be rescued via an emergency cesarean sections and whether the defendants failed to rescue him. Choice of words in wording issues is obviously important too. And so the third issue will be whether the failure to diagnose and treat this lack of oxygen caused damage to this brain. The defendants may argue in such a case. The real issues in this case are very straightforward. They are, number one, whether this labor and delivery was or was not managed by a team of well-trained, highly experienced, caring, compassionate professionals. We say they were, says the defendant. And second, the defendant may argue, the second issue in this case is whether this labor and delivery in fact went well and without complications. We say it did, says the defendant. And the third issue in this case, the one the defendant will probably spend most of their time on in my example, is whether this child's brain disorder occurred during the prenatal period months before labor and delivery ever took place. Now, in trying to keep the jury's attention focused on your issues, let me be very clear about this last point. Although you should try your hardest never to fight their issues directly, in their words, on their turf, on their grounds, I'm not for a moment suggesting that you can ignore the other side's arguments, and please don't for a moment misunderstand that. I'm not suggesting that the other side's issues can be ignored. The trick, the goal, the desideratum, if you will, is to disprove their contentions indirectly while in the process of making your affirmative points. So that you're not going, okay, let me talk about the defendant's three issues, A, B, and C, and tell you why they're not so on summation, or doing that in effect while examining a witness. but rather in the process of you're making your points 1, 2, and 3, being able to point out, and by the way, that's certainly not so, and by the way, that certainly doesn't make sense for the following